Imagine this terrifying scene unfolding in the quiet suburbs of Sydney. It's late, well past midnight, and you're just getting home.
Right.
As your car pulls into the familiar driveway, dark figures seem to materialize out of the night. They're masked, they're armed, and they are definitely not there for a friendly visit. They force their way inside, turning your home into a place of absolute terror. Your family is threatened, ordered around, made to lie helpless on the floor.
Just awful.
Then the unthinkable happens, a violent struggle, shots ring out, a life is extinguished, another person wounded. This chilling sequence of events wasn't fiction. It was the horrifying reality faced by the Legozzo family on January 7, 2002.
And that horrific crime, the home invasion in Cecil Hills that resulted in murder, was really the catalyst for a legal battle that would ultimately reach the very pinnacle of the Australian justice system, the High Court.
Wow.
But the case wasn't just about the brutality of the crime itself. It became this landmark dispute centered on how police obtained a critical piece of evidence. We're talking about a conversation police had with a young man suspected of being involved, a conversation obtained under circumstances that would be meticulously dissected in courtrooms for years, leading to the case known as Em v. the Queen.
Okay, let's unpack this incredible story. In this deep dive, our mission is to take the stack of sources you've given us, the articles, the research notes, the, detailed accounts of what transpired, and guide you through this complex narrative.
Yeah, there's a lot to cover.
We need to understand not just the terrifying crimes, but the people caught up in them, the challenging police investigation that followed, and the intense legal fight over a single piece of evidence.
Exactly. Why did the method of obtaining that evidence matter so much? What does Em v. the Queen reveal about that really delicate balance between solving serious crimes and protecting fundamental individual rights? Those are the core questions.
Right.
At the heart of the investigation and the subsequent legal challenge is Sophear Em. He was just 19 years old when these offenses took place.
So young.
Yeah, a very young man whose alleged involvement would lead him all the way to the High Court as the appellant in this case. And his later claims about why he spoke to police, about a strategy to protect friends, believing what he said couldn't be used against him, well, that becomes absolutely central to the legal arguments.
Okay, so his state of mind is key. And navigating the initial investigation, applying pressure, and ultimately conducting the key interview were detectives Abdi and Aklim.
That's right. The sources show they weren't static in their approach. They shifted tactics, moving from those formal police station interviews to the highly unconventional and legally contentious informal conversation in a park.
That park interview. We'll definitely get into that.
Oh, yes. Their strategic choices in how they pursued Em would be the focus of intense scrutiny.
And of course, a legal saga like this involves numerous judicial figures grappling with complex questions.
Absolutely. From the judges who heard the initial trials and appeals, Shaw J., James J., and the panels at the NSW Court of Criminal Appeal to Justice O'Keefe J., who issued the warrants for the listening devices.
Right, the warrants are important.
Crucial. And then finally, the 5 justices of the High Court. Chief Justice Gleeson and Justices Hayden, Camo, Hain, and Kirby. Their differing interpretations of fairness and evidence law really underscore the difficulty of the issues at play here.
So, to really grasp the magnitude of the legal fight, you first have to feel the weight of the crimes themselves. The sources paint a chilling picture of 2 separate but linked home invasions that brought terror to quiet suburban streets.
That's right. The first and most tragic was the Legozzo home invasion on January 7, 2002. Mr. and Mrs. Legozzo were just returning to their home in Cecil Hills late at night when they were ambushed.
Just coming home.
Yeah. The sources described 2 figures in dark clothing wearing balaclavas and large ski goggles disguises designed for one purpose: anonymity.
Couldn't be identified.
Exactly. One was armed with a rifle, the other with a pistol.
And they weren't just there to steal, they were there to dominate and instill fear.
Precisely. They forced the Legozzos inside and then went through the house, forcing the other occupants, Julian, Natalie, and Robert, who were asleep upstairs, down to the lounge room.
Oh, God.
They were threatened, made to lie on the floor. It's impossible to imagine the sheer terror of that moment, lying there, helpless at gunpoint in your own home.
Absolutely unimaginable, and the situation escalated violently.
It did. The sources detail how the intruder with the rifle took Mr. Legozzo upstairs to locate valuables. A struggle broke out, first on the stairs, then continuing into the lounge room.
Chaos.
Complete chaos. It was during this struggle that the man with the pistol shot Mr. Legozzo in the chest. Mrs. Lugoso, understandably, rushed to her husband's aid, and she too was shot in the hand by the same gunman. The intruders fled immediately after this. Significantly, the sources note that no property was actually stolen, suggesting the violent confrontation sort of aborted their original plan.
The struggle maybe interrupted them.
That seems to be the suggestion. Tragically, Joseph Lugoso was pronounced dead at the hospital.
The sources really emphasize those disguises, the balaclavas, the large ski goggles. They were so effective that none of the victims could provide any identifying features of the attackers.
Right, which posed a huge challenge for the investigation.
This meant police couldn't rely on standard victim identification lineups. They had to look elsewhere for leads.
And just 10 days later, on January 17th, a second, strikingly similar home invasion occurred nearby in West Hoxton.
So close and so soon after.
Exactly. This time, it was 3 men, again in dark clothing and balaclavas, 2 with ski goggles, armed with a pistol, a rifle, and a knife. They arrived in a stolen car that police would later recover.
So the pattern is clear. Multiple armed intruders, effective disguises, nearby locations, a very short time frame between the attacks. This naturally led police to suspect a connection.
Absolutely. The sources describe Mr. Michael Kress being confronted in his garage and forced inside. The other occupants, his wife Beverly, son Jonathan, daughter Allison, and her boyfriend Ramsey Tamer, were all forced into the bar area, hands tied, mouths taped.
Tied and taped. Complete control.
Total control. They were subjected to terrifying threats, including warnings of death if they called the police too soon. This time, the intruders were successful in stealing numerous items.
And Em was involved in this one.
The sources state that Sophear Em later admitted to police that he was one of the 3 men involved in this Kress invasion.
Okay, so police had Em linked to the Kress case through his own admissions. And based on the chilling similarities between the 2 invasions, they strongly suspected his involvement in the Lugoso murder.
That was their working theory.
But without direct evidence like victim identification for Lugoso, they needed more. This pushed the investigation into different territory, leading to the first formal interview.
Right. Police investigated, gathering what the sources describe as circumstantial evidence linking M to the area and potentially the individuals involved. On April 24, 2002, Sophear Em was brought into the police station for questioning by detectives Abdi and McLean.
This is where the issue of electronic recording first comes to the forefront, isn't it? Setting the stage for the later legal arguments.
It certainly does. The sources detailed that the detectives began questioning M, initially focusing on the Kress invasion, putting circumstantial matters to him. A few minutes in, M expressed his clear reluctance to have the conversation recorded.
He didn't want it taped.
He said, twice, that he didn't want anything on the tapes. After the second refusal, he then surprisingly asked, "But what do you want to know? Like, where is the gun and stuff?"
Huh. That's odd. Wants to talk, but not on tape.
Very odd. This willingness to talk, coupled with the condition of not being recorded, presented the detectives with a choice. The sources state the detectives left the room.
Okay, they stepped out to confer. Maybe.
Presumably. And upon their return, Detective Abdi asked if he was willing to talk. M reiterated his condition. Not if it's on the tapes.
Sticking to his guns on that point.
Absolutely. According to the sources, Detective McLean responded directly to this, saying, "There, I've turned it off, even our phones are off," and physically turned the recording machine off.
Whoa, okay, so they explicitly turned off the official record because he asked.
That action, turning off the official record in response to M's condition, is crucial. M then asked, perhaps showing some media awareness, "What about a wire, like in the movies?"
Like in the movies.
Yeah. Detective Abdi's response was, "I'm not going to sit here naked with you, mate. You'll just have to trust us. We have been up front with you from this morning, and we haven't tried to trick you."
So a direct promise of trust and not being tricked immediately following the act of turning off the recorder, responding to M's specific condition. That sounds significant.
Extremely significant, as the later legal arguments would show. The sources describe questioning continuing without the official recording. It was during this part of the interview that M made admissions about his involvement in the Kress invasion, including being in possession of a silver pistol used.
Did he say why they chose that house?
He did. He provided details like why they chose that house. They just looked rich, nice house, they had Commodore in the driveway, but he declined to name his co-offenders.
Okay, so having got admissions about Kress, the detectives then shifted focus to the Lugoso murder. What happened then?
The sources state Detectives Abdi and McLean returned and began questioning M about the Lugoso home invasion. Before starting this line of questioning, Detective Abdi administered a partial caution.
Partial? What does that mean?
He told M, Sophia, there's one other thing that we want to speak to you about, so just listen to what we have to say. You don't have to say or do anything unless you want to.
Okay, that's the standard first part of the police caution, informing you of your right to remain silent.
Correct. But the second, equally crucial part of the standard caution, but whatever you say or do may be recorded and later given in evidence at court, was conspicuously omitted.
They left that bit out. Why?
That's the million-dollar question, isn't it?
Hmm.
M's immediate response to the partial caution, I don't want anything recorded.
Again, he's very consistent.
Very. And Abdi's reply mirrored the earlier interaction. It's the same as before. Nothing in this room is turned on.
Wow. It sounded like the police were deliberately playing into his apparent belief that if something wasn't recorded, it couldn't be used against him.
That's precisely what the defense would later argue, and it's hard to see it any other way based on the sources. The sources indicate Detective Abdi then suggested turning the machine back on, at which point M became visibly distressed, began to cry, and asked for a solicitor.
So he realized things were getting serious.
It seems so. His request for a solicitor was facilitated. After speaking with a lawyer, M returned, but he continued to refuse to have anything recorded or notes taken, stating he didn't want to talk about it just now and would say what happened in court.
Okay.
Despite the admissions about Kress and their suspicions about Lugozzo, he was released without charge soon after this interview.
Released, even after admitting involvement in the Kress robbery.
Yes. The sources suggest the police later testified they didn't believe the unrecorded statements would be admissible in court, which is why they felt they didn't have sufficient evidence to charge him then, even for the Kress offenses.
So this initial interview reveals M's vulnerability, his clear condition about not being recorded, and the police's willingness to meet that condition while offering assurances of trust. This sets the stage for the controversial tactical shift that led to the pivotal Park interview.
Yes, by early May 2002, understanding M's aversion to formal, recorded settings, Detectives Abdi and McLean decided on a different strategy, one that would allow them to record the conversation without M's knowledge.
Covertly.
Exactly. They sought and obtained judicial authorization for this. They went before Supreme Court Judge O'Keefe J. and secured warrants under Section 16 of the Listening Devices Act 1984, NSW. These warrants legally authorized the detectives to wear and use covert listening devices to record their conversations with M.
So the act of secretly recording him was now perfectly legal because they had a warrant. That's important.
That's a key legal point the courts would later affirm. The recording itself was lawful. Their first attempt using this approach was on May 13th. They went to M's residence, equipped with the covert devices. M wasn't home, but they spoke to another occupant.
Laying the groundwork.
Seems like it. Emphasizing that they weren't there to arrest him or take him to the station. They just needed to talk. The sources suggest this was a deliberate attempt to communicate this message to M and set the expectation of a low-key, informal chat.
This is a significant shift from the police station. They're moving towards a less intimidating, less formal environment while simultaneously arming themselves with secret recording technology. It's a calculated strategy.
Absolutely. It highlights their determination to get M to talk and their understanding that a formal recorded setting was basically a non-starter for him. They were laying the groundwork for the conversation that would become the focal point of the entire case.
And that conversation happened just 2 days later, on the morning of May 15th, 2002. This is the Park interview, the short, secretly recorded chat that would fuel years of legal argument and define the MV the Queen case.
That's the one. On that morning, Detectives Abdi and McLean again went to M's residence. They were both wearing the covert listening devices authorized by Justice O'Keefe's warrants.
Ready to record.
Ready to record. M answered the door, still in his night clothes. The detectives told him they wanted to talk, showed him some photos, and that it would only take 5 or 10 minutes. Crucially, they explicitly repeated the message they had tried to relay earlier. They were not going to the police station.
Reinforcing that informal feel.
Definitely. They then drove him a short distance to a nearby park.
The setting alone is designed to feel casual, informal, not like a formal police interview.
Exactly. And in the car, on the way to the park, the sources detail a critical exchange. Detective Abdi reminded M of their earlier police station interview and the paper he'd been given about his rights.
The one saying he didn't have to talk.
Right. M acknowledged this, saying, "Yeah, I know that." Abdi then repeated the first part of the caution. And the same goes again. You don't have to say anything to the police if you don't want to, okay?
But again, the second part was left out, the part about what he said being recorded and used in court.
Absolutely. That crucial warning was omitted. The sources are explicit that the detectives later testified they deliberately left out the second part of the caution, specifically to avoid alerting M to the fact that he was being recorded, knowing he wouldn't speak if he knew.
So they knew he believed that unrecorded conversations couldn't be used against him, and their actions omitting the caution, choosing the park setting, offering assurances arguably played directly into that belief. That seems problematic.
That was the central argument of the defense. The sources confirm M held this mistaken belief about the inadmissibility of unrecorded statements and that police were aware of it. Throughout the conversation, the detectives offered repeated assurances. They told M they weren't trying to trick or con him, emphasizing they had been upfront.
Upfront while secretly recording him.
Well, quite. Detective McLean even specifically referenced the April 24th interview, saying, "Mate, you know yourself that day that nothing was recorded. You know that."
Which, as the dissenting judge later pointed out, could very easily have reinforced M's mistaken belief that this conversation, happening outside the station and with assurances, was also effectively off the record.
That's a key interpretation, certainly the one Justice Kirby focused on. The conversation itself was informal, but the questioning was persistent and clearly focused on the serious home invasions and the murder. M was aware of the gravity of the discussion.
He knew what they were asking about.
Oh, yes. He asked the detectives if they thought he was involved and reiterated that he'd told you guys everything already.
And then we get to the point that the court would later mark as a potential turning point, the P25 statement. What was that?
Okay, so the transcript of this Covert Park conversation ran to 40 pages. Justice James J., who presided over the second trial, would later identify a specific exchange on page 25 as highly significant. Detective Abdi said to M, "Maybe you might feel better if you tell us. It's not as though we're going to slap the handcuffs on you and take you away, otherwise we'd be at the police station if we were going to do that, wouldn't we?"
Wow. That statement seems to draw a direct link between the informal setting, not at the police station, the lack of immediate arrest, not going to slap the handcuffs on you, and the implication that what he said couldn't lead to immediate consequence, playing right into his mistaken belief.
That's precisely how James J. and later the dissenting high court judge interpreted it, that it crossed the line from passively allowing a belief to actively encouraging it. The Crown, for their part, argued that during this Park conversation, both before and after that P25 statement, M made alleged admissions linking him to the Logoso offenses.
Like what?
For example, responding to a query about his involvement in the home invasion or the murder, he allegedly asked that I did both. He also allegedly made admissions about the pistol used. This entire 40-page conversation was secretly captured by the covert devices, forming the core evidence the prosecution desperately wanted to use.
And this leads us directly into the complex legal gauntlet that followed. The central question wasn't just about what M said, but whether and how the secretly recorded conversation, obtained under these specific circumstances, could be used against him in court.
Exactly. This became an intense legal battle focused on several key provisions of the Evidence Act, 1995, NSW. The primary battleground was Section 90, which allows a judge to exclude evidence of an admission if admitting it would be unfair to the defendant.
Unfairness, that sounds broad.
It is, and that breadth was part of the debate. But they also considered Section 138, which deals with improperly obtained evidence, Section 84, regarding admissions influenced by violent or inhuman conduct, though that wasn't really the issue here, and Section 85 concerning the reliability of admissions.
So the defense mounted a challenge under multiple sections, arguing this evidence should be kept out.
They did. The first time this issue was tested was in a pretrial hearing known as a voir dire before Justice Shaw J. The defense argued the evidence from the May 15th Park conversation was obtained improperly and unfairly.
And what did Shaw J decide?
Justice Shaw J agreed with the defense, ruling to exclude the evidence entirely. He found it would be unfair to M to use it, primarily under Section 90. He also accepted that it was obtained improperly under Section 138, even while acknowledging that the police subjectively believed they were acting properly with the warrant.
So the first judge to consider the issue found the evidence too tainted to be used, the whole conversation out.
That was his initial ruling. However, the prosecution appealed this decision to the NSW Court of Criminal Appeal. This was the RVM appeal in 2003.
The Crown fought back.
They did. The appeal judges, Howie J., Ip J.A., and Holm J., reviewed Shaw J.'s decision. They ultimately reversed his ruling, finding that his exercise of the Section 90 discretion had miscarried because he had taken into account factors they deemed irrelevant.
What factors?
They drew a distinction which would echo through later decisions between police merely failing to correct a suspect's pre-existing mistaken belief and police actively confirming or inducing that belief. They felt Shawjay hadn't properly focused on that distinction.
Ah, the difference between letting someone be wrong and encouraging them to be wrong.
Sort of, yes. They hinted that the line for unfairness might only be crossed later in the conversation, perhaps around the point that would become known as P25. They also reversed the S-138 exclusion.
This meant that the admissibility of the park conversation was still up for grabs for the second trial. The issue had to be decided again.
Precisely. The second trial was held before Justice James J. He had to decide the admissibility issue anew, but now with the guidance from that first NSWCCA appeal decision.
Okay, what did James J. find?
Justice James J. made several crucial findings of fact. He accepted that M did have a pre-existing belief formed before the May 15th interview that unrecorded statements couldn't be used against him. He also accepted that the police knew M wouldn't speak if he thought he was being recorded.
So he accepted those key background facts?
Yes. He then examined sections 84, 85, and 138, but found they didn't require excluding the evidence for the initial part of the May 15th conversation.
But he didn't admit the entire conversation, did he? This is where P25 comes in again.
Exactly right. This was a key pragmatic decision. Justice James J. ruled that the evidence from the May 15th conversation up to Detective Abdi's significant P25 statement was admissible.
The bit about not slapping the handcuffs on.
That's the one. He drew a line in the sand right there. He excluded everything M said after the P25 statement under Section 90, finding that that specific statement actively induced or promoted M's mistaken belief, making any admissions made after that point unfair to use against him.
So a split decision on the transcript itself, first 25 pages in, the rest out.
Correct. Only the first 25 pages of the 40-page transcript, with some editing, were allowed to be put before the jury.
This meant the jury would hear some of the alleged admissions, but only those made before that potentially deceptive statement by Detective Abdi.
That's right. M's second trial proceeded with this limited evidence from the park conversation. M himself gave evidence in his defense.
What was his defense?
His strategy was to claim that he had lied to the police in the park as a deliberate strategy to protect his friends, individuals like Malvan and Leanne, who the sources mentioned were involved in the Crest case.
He said he lied to protect others.
Yes. He testified that he made these false admissions implicating himself because he believed they couldn't be used against him since the conversation wasn't being recorded in his mind. He even stated, "Because if I did not do this crime, how could I be charged for it?" This put his mistaken belief and the reliability of his statements squarely before the jury.
It's a risky defense, admitting to lying to the police but claiming it was part of a plan based on a misunderstanding of the law. I lied, but it doesn't count.
It is, but it directly challenged the weight and reliability of the admitted evidence, given the context in which it was obtained and M's claimed state of mind. Despite this defense and the arguments about his mistaken belief, Sophear Em was convicted of the Legozzo offenses, including murder.
Convicted of murder.
Yes. The sources note that the murder conviction was likely based on the principle of constructive murder or felony murder, essentially. That a death occurred during the commission of a serious crime like armed home invasion, which M was found to be part of. It wasn't necessarily based on finding he was the person who fired the fatal shot.
Because they couldn't identify the shooter?
Well, the identity of the second Legozzo intruder, the rifleman, wasn't definitively established at trial. Although Malvan was an offender in the Crest case, James J. wasn't satisfied beyond reasonable doubt that he was the second Legozzo offender.
Okay. Following his conviction, M appealed again to the NSW Court of Criminal Appeal. This is the second appeal. M v. Regina in 2006. What did he argue this time?
His appeal focused on two main areas. Challenging his conviction based on James J.'s AS-90 ruling, arguing the entire conversation, or at least more of it up to P25, should have been excluded, and arguing that the trial judge should have given the jury a specific warning about the potential unreliability of his admissions, given his mistaken belief.
The jury warning argument again.
Yes. He also appealed his sentence for the Crest offenses and how it was ordered to be served consecutively to the life sentence for murder, arguing it was too harsh compared to others involved like Malvan, raising issues of parity.
And how did the NSWCCA respond to this second appeal? Did they agree with him this time?
No, they didn't. The appeal panel, Giles J.A., Grove J., and Hidden J., dismissed both the appeal against conviction and the sentence appeal. They upheld James J.'s 90 ruling, essentially agreeing with his reasoning.
Sticking with the P25 distinction.
Yes, agreeing that failing to correct a pre-existing belief was distinct from actively confirming or inducing it, and finding no such unfair conduct by police before P25. They also rejected the argument for a specific jury warning.
Why no specific warning?
They reasoned that the defense had thoroughly explored the issue of reliability and Em's claimed motives for speaking during the trial. The judge's general instructions to the jury on evaluating evidence and witness credibility were deemed sufficient to cover these points. They basically said the jury had all the information they needed to assess it.
And the sentence?
They upheld the sentences and the order for them to be served consecutively. They noted Em's involvement in the Crest robbery after the Legozzo murder as an aggravating factor and found no error in declining special circumstances or breaching sentencing parity principles compared to Malvan's sentence, which, importantly, also included a different, unrelated murder conviction.
Okay. So after being heard by a trial judge, the first court of criminal appeal, a second trial judge, and a second court of criminal appeal, the decisions had consistently gravitated toward admitting at least part of that controversial part conversation. But the legal battle wasn't over. Em sought permission to take his case to the highest court in Australia.
And special leave was granted for Sophear Em to appeal to the High Court of Australia. This is the big one, M v. the Queen, decided in 2007. The appeal zeroed in on those two central evidence issues that had been debated through all the lower courts. The S90 unfairness ruling regarding the admissibility of the May 15th conversation up to P25, and the argument that the jury needed a specific direction on the reliability of the admissions given Em's mistaken belief.
All right, the High Court. What were the core arguments the appellant, Sophear Em, put before them on the crucial issue of unfairness under Section 90?
Em's legal team argued passionately that using the evidence from the park conversation was profoundly unfair. They contended that the police had deliberately exploited Em's known mistaken belief that unrecorded conversations weren't admissible through a pattern of deceptive conduct.
The whole pattern, not just one statement.
Their argument was about the cumulative effect. Giving an incomplete caution, choosing the informal and disarming park location, offering repeated assurances that they weren't tricking him, and secretly recording him despite his clear earlier resistance to recording. They argued this police conduct fundamentally undermined Em's right to silence and his ability to make a free and informed choice about speaking.
So they wanted the court to look at the totality of the police actions.
Precisely. They argued Section 90 should protect against this kind of tactic, reflecting the broad common law discretion to exclude evidence where its admission would be unfair, a principle often referred to as the Lee discretion. They saw the case as analogous to R.V. Swaffield, where admissions were excluded partly because no caution had been given, undermining the suspect's choice.
So their argument was that even if technically lawful, because of the warrants, the method used to get Em to talk was unfairly manipulative, considering his known vulnerability.
Exactly. They focused on the police conduct and how it interacted with Em's state of mind and his mistaken belief. The Crown, representing the Queen, countered this forcefully.
What was the Crown's position?
They argued that admitting the evidence was not unfair. They contended that police did not create or induce Em's mistaken belief. He already held it. The covert recording itself was entirely lawful due to the warrants obtained from Justice O'Keefe. They emphasized that Em had been made aware of his right to silence multiple times, including the partial caution on May 15th, and therefore his choice to speak was a free one.
And how did they frame Section 90? Did they see it as this broad fairness protection?
Not quite. The Crown argued that Section 90 acts as a safety net, but it's primarily there to catch situations not already covered by the more specific exclusionary rules like Section 85 reliability and Section 138 improperly obtained evidence.
Sort of a last resort.
That was their framing. Since, in their view, the police conduct didn't trigger exclusion under those more specific rules for the conversation up to P25, because the recording was lawful, Em wasn't technically under arrest for S-139, and the police statements weren't legally false statements under S-138-2B. Section 90 shouldn't be used as a means to simply rerun arguments about impropriety or reliability that had already failed under the specific sections.
It sounds like the Crown took a more technical, narrow view of when police conduct crosses the line into unfairness or impropriety.
They certainly focus on the specific wording of the act. Their position was that as long as the recording was lawful and the suspect was generally aware they didn't have to speak, the police were entitled to use tactics that might exploit a suspect's pre-existing misunderstanding.
And the jury warning argument.
Em's team argued that if the jury found M did believe his statements couldn't be used. That belief fundamentally undermined the usual assumption that admissions are reliable, because people speak against their interest only when it's true. They argued the jury needed a specific direction from the judge to be cautious about relying on the admissions, especially given M's stated motive to protect his friends.
Makes sense. If you think it doesn't count, maybe you would lie.
That was the logic. The Crown's response again was that this issue had been fully explored during the trial. They contended the defense had squarely put M's claimed motive and his mistaken belief before the jury, and the judge's general directions on assessing the credibility and reliability of all the evidence were sufficient. No need for a special warning.
So, the High Court was presented with a fundamental disagreement about the meaning of unfairness and the boundaries of acceptable police tactics when dealing with a suspect who has a known misunderstanding of the law. How did the highest court in the land rule?
In a 4.1 majority decision, the High Court dismissed Sophear Em's appeal, upholding the decisions of the NSW Court of Criminal Appeal.
4-1 against M, who formed the majority.
Chief Justice Gleeson and Justice Hayden delivered a joint judgment, and Justices Gummo and Hayne delivered a separate joint judgment agreeing on the outcome. All four agreed that the appeal should be dismissed. Justice Kirby delivered a powerful dissenting judgment.
Let's break down the majority's reasoning, starting with their view on Section 90 fairness.
The majority confirmed their view that Section 90 operates as that safety net provision, considered after the more specific exclusionary rules like 85 and 138 have been examined. They found that Section 138, improperly obtained evidence, did not apply here.
Why not? It felt improper to many.
Because the covert recording itself was lawful due to the warrants. They specifically held that the police failure to give the full caution, omitting the part about the conversation being recorded and used in court, did not make the evidence improperly obtained under the specific definitions provided in Section 138(2) or Section 139 of the Act.
Based on technicalities again.
Based on the precise legal definitions in the Act. For instance, they determined that M was not under arrest, in the sense required by Section 139 for certain caution rules to apply strictly. And the police statements weren't considered false statements in the narrow legal sense under Section 138(2)(b).
So they took a very strict reading of those sections.
They did. And applying Section 90, the majority concluded that the use of the evidence from the park conversation up to the P25 statement was not unfair.
Not unfair, despite everything.
Their key reasoning was that M's belief that unrecorded statements were inadmissible was something he held independently. The police were not responsible for creating this belief. They characterized it, rather bluntly perhaps, as a form of ignorance or stupidity for which the police shouldn't be held responsible.
Ignorance or stupidity. Wow.
Yes. Therefore, merely being aware of this existing belief and failing to correct it was not enough, in their view, to make the subsequent use of the evidence unfair under Section 90. They found that M's freedom to speak was not impugned. He spoke knowingly and willingly, having been reminded he had a right to silence, even if not fully cautioned about the recording and its consequences.
They drew a sharp line between police causing a misunderstanding and simply benefiting from one a suspect already has, and they felt benefiting was okay here.
That was the effect of their decision, yes. They distinguished Swafield by noting that in that case, the suspect received no caution at all, while M had received the first part of the caution multiple times, reinforcing his general right to silence.
And the jury warning.
On the jury warning, the majority agreed with the NSW-CCA that a specific warning was not required. They felt the defense had sufficiently raised the issues of reliability and M's claimed motive at trial, and the general directions to the jury were adequate.
So the majority essentially prioritized the admissibility of relevant evidence obtained through means that were technically lawful, even if those means capitalized on a suspect's misunderstanding. But Justice Kirby saw it very differently.
He did. Justice Kirby's was a powerful dissent. He argued that the use of the evidence was fundamentally unfair and that the entire May 15th conversation should have been excluded under Section 90.
The whole thing.
The whole thing. He took a much broader view of Section 90, arguing that it fully preserves the common law lead discretion, which is designed to ensure fairness and protect the right to silence against tactics that might induce a suspect to speak based on a misapprehension, especially as police conduct contributes to or exploits that misapprehension.
He felt the police conduct did undermine M's rights, didn't he?
Absolutely. Justice Kirby believed the combined effect of the police's actions, the intentional omission of the second part of the caution, deliberately choosing an informal park setting, the repeated assurances that they weren't tricking him, and exploiting his known belief that unrecorded conversations were safe amounted to trickery.
He used the word trickery.
He did. He argued this conduct directly impinged on Em's right to silence and his ability to make a genuinely free and informed choice about whether to speak. For him, the unfairness lay precisely in this manipulative method used to elicit the admissions.
He saw the case as being very much in line with Sophear then.
Yes, Justice Kirby saw the case as analogous to Sophear, where police conduct, or lack thereof, like omitting the caution, led to the suspect speaking under circumstances that derogated from their free choice to remain silent. He was critical of the majority's distinction between a pre-existing belief and actively confirming or inducing it.
He thought that distinction was artificial.
He viewed it as artificial in the context of what he saw as a single, planned strategy by police to get Em to talk by exploiting his known vulnerability. He also viewed Justice James J's P25 distinction as equally artificial, arguing the unfairness permeated the entire conversation from the moment they started exploiting his belief. So, Justice Kirby saw Section 90 as a crucial safeguard to uphold fundamental principles of the justice system, even against tactics that might fall just short of being technically improper under other specific rules. Exactly. He emphasized the importance of Section 90 in protecting the accusatorial system, where it's up to the prosecution to prove guilt and the right to silence, against tactics that might subtly compel self-recrimination from someone like Em, operating under a known critical misunderstanding. His dissent highlighted that deep tension between effective law enforcement and maintaining the integrity and fairness of the justice process.
Em v. the Queen clearly wasn't just about Sophear Em's guilt or innocence. It became a defining moment for how courts in Australia would interpret the rules around evidence and fairness, especially with covert recording involved. What has been the impact and significance of this case on Australian legal practice?
Well, it certainly provided a definitive High Court interpretation of Section 90 of the Evidence Act, clarifying its role. It confirmed that Section 90 is primarily that safety net.
The majority view prevailed.
Yes, and it reinforced their view that simply failing to correct a suspect's pre-existing mistaken belief is generally not enough to trigger unfairness under Aaron's 90, particularly if the recording itself was lawful and some form of caution about the right to silence was given. This drew a clearer, albeit controversial, line for police and lawyers.
It really crystallizes that ongoing tension you mentioned, the balance between giving police the tools to investigate serious crimes and protecting the rights of the accused.
It absolutely does. The majority decision in Em arguably tilted that balance somewhat toward admitting probative evidence obtained through technically lawful means, even if it means capitalizing on a suspect's lack of legal understanding or, as the majority put it there, ignorance or stupidity.
Oh.
The dissent, on the other hand, argued for a stronger emphasis on fundamental rights, viewing certain tactics as inherently unfair, regardless of their technical legality. This philosophical debate continues to inform how judges apply evidence law day to day.
Did the case lead to changes in police procedure, do we think?
It's hard to say definitively without internal police reviews, but landmark cases like Em inevitably lead police services to review their practices. While covert recording remains a vital tool when authorized by warrant, the case reinforced the critical importance of administering full and proper cautions, even in seemingly informal settings.
Unless there's a very good reason not to.
Right, and understanding the potential consequences for admissibility if you omit part of it. It likely led to increased training on managing suspect expectations and the ethical tightrope walk involved in using tactics that might exploit suspect misunderstandings, even if deemed lawful by the High Court. It underscored the needs for police to be meticulous in their process if they want the evidence they gather to hold up in court.
And for the judiciary, it gave them clearer rules.
It provided clearer, albeit sometimes debated, guidance on applying Section 90 and distinguishing it from other exclusionary rules like 138 and 85. But the strong dissent from Justice Kirby also serves as a constant reminder of the competing values at play and ensures that arguments about the fairness of obtaining evidence continue to be robustly debated in courtrooms.
It's not a settled issue then, despite the High Court ruling.
The specific legal points might be settled for now, but the underlying tension isn't. As investigative technology continues to advance, think sophisticated surveillance, digital footprints, perhaps even future AI tools for interrogation or analysis.
Scary thought.
Right. The principles grappled with in Em remain highly relevant. The challenge of how to balance the state's increasing power to gather information with the individual's right not to be unfairly compelled to incriminate themselves will persist, and the framework refined in Em v. the Queen will continue to be the lens through which those future challenges are viewed.
So, why does a case involving a home invasion in Sydney back in 2002 and a legal fight over a recorded conversation in a park matter to you listening today?
Because it gets right to the heart of fundamental questions about justice and your own rights. What are your basic rights if police want to talk to you? How careful do you need to be about what you say, even in a conversation that feels casual or off the record?
Especially if you think it's off the record, but it isn't.
Exactly. How does the law decide when police tactics have crossed the line from legitimate investigation to unfair manipulation?
It highlights just how complex the idea of fairness is within the legal system, especially as technology gives investigators powerful new tools.
It truly does.
Yeah.
And it shows that the law is constantly playing catch-up, trying to apply principles developed over centuries to a rapidly changing world.
We've taken a deep dive from the horrific reality of those home invasions, through the strategic moves of the police investigation, and into the incredibly detailed and high-stakes legal arguments that took Sophear Em's case all the way to the High Court.
And what Envy the Queen ultimately shows us is the difficult line the courts are forced to draw. It's the line between allowing police effective means to combat serious crime, which, as the High Court majority accepted, may sometimes involve tactics like covert recording and benefiting from a suspect's mistakes, and upholding fundamental individual rights, like the right to silence and protection from being unfairly induced to incriminate oneself.
And that leaves us with a powerful question to ponder. In a world where technology offers increasingly sophisticated ways to gather information, how should the law balance the needs of effective investigation with the fundamental right of an individual not to be unfairly pressured into self-incrimination? Where do we draw the line on what constitutes fair, and how do we ensure that line protects everyone, regardless of their understanding of the law, or, dare I say it, their perceived ignorance or stupidity?
That's the enduring question, isn't it? It's a question that cases like Envy the Queen don't fully answer, but they absolutely force us to ask.